Good morning. This week's topic is the constitutional limits on criminal law. We're going to work our way through the PowerPoints and kind of some of the main topics in this chapter 2 chapter. One of the largest concepts in this chapter is the principle of legality. And this is that we should not convict or punish people for crimes unless the crime is defined by the law and the punishment is set by the law, and that the behavior the person engaged in is defined as a crime. This idea is seminal to criminal law. Every other concept we talk about is going to come second behind this concept. No crime without law, no punishment without law, even if that means that someone who is violent walks free. Okay? One reason why we know this concept is seminal to criminal law is that it's actually embodied in the Constitution. Article 1 of the Constitution contains a ban on ex post facto laws. An ex post facto law is essentially a retroactive application of the law to a behavior. So it can either criminalize an act after you did it, increase the punishment after you did it, or take away a defense after you did the behavior. This protects individuals. It makes sure that we all have fair warning about what is a crime and what is not. And it means that we can't, that legislatures can't pass kind of like random or arbitrary laws. They can't look at a behavior by someone that's pretty heinous and then say, you know what, we're going to pass this law to make sure you get this extra punishment. So it helps it's really a goal to help protect individuals. Okay. Another principle of legality is the void for vagueness doctrine. So again, remember that principle of legality is that it's not a crime unless it's defined by the law, and the punishment is defined by the law, okay? And then a subset of this is this idea of void for vagueness. So when a legislature passes a law, it needs to define a crime and its punishment clearly enough so that an average person could understand what is lawful and what is not. If the law does not do that, if it does not tell us what is criminal and what is not, then it is void for vagueness because it violates the due process clauses of the 5th and 14th Amendments of the Constitution. It helps make sure that we have fair warning about what's criminal and what's not, and it helps reduce arbitrary and discriminatory law enforcement. Okay. Now, what is vague is this is another kind of question. Let's just want to make sure it's not. In general, things that are vague. Well, let's do an example. Your book has a chapter called State v. Metzger. On page 45. So in 1982, the Nebraska Supreme Court determined that a city ordinance was void for vagueness. And that city ordinance prohibited any indecent, immodest, or filthy act. And Douglas Metzger lived in an apartment on the ground floor. And one morning, a resident parked in front of his window, just in a normal parking spot, and Doug was standing in front of that window naked with his arms at his side for about 5 seconds. That person called the police. The police came about 15 minutes later, and when police officers arrived at Doug's apartment, he was standing naked in front of the window eating a bowl of cereal. Okay. And so he was charged and ultimately convicted of engaging in an indecent, immodest, or filthy act in the presence of a person. Um, and so the question is, what do those words mean? What is indecent? What is immodest? What is filthy? We each kind of have our own take on a lot of those words. Those words are not necessarily clear. For instance, one of my grandmothers would say that using a swear word would meet these criteria. It's immodest and it's filthy. And people who swear in front of her are engaging in this immodest, filthy conduct. My other grandmother completely disagrees. And so it's one thing about what Doug was doing. He was, in his apartment, and he was naked in his apartment. We're allowed to be undressed at our home. So this law is vague, and the Nebraska Supreme Court struck it down. So when we're talking about something that's vague, those are the kinds of things we're talking about. All right. Our next concept in this chapter is the rule of lenity. The rule of lenity mandates that if there's an ambiguity in a criminal statute, if there is not clarity in some issue, that the lack of clarity is resolved in favor of the defendant. So if the criminal law can mean more than one thing, the interpretation of it that is the most fair to the criminal defendant is the one that the court needs to use, okay? So that's what the rule of lenity is. It sounds really big, but it really is small. It's very narrow in practice. Okay. So courts aren't really like running around throwing out lots of criminal laws or deciding in favor of criminal defendants very frequently. All right, the next concept up here is proving guilt in criminal cases. So we have proving criminal conduct. And we start off with the idea that every defendant is presumed innocent. The burden of proof is on the prosecutor. The prosecutor needs to prove every element of a crime beyond a reasonable doubt. Proof beyond a reasonable doubt is the standard in criminal cases. It is the highest standard of proof in any court in the country. And everyone defines it slightly differently. But if you think of a threshold of 80% or higher, you're in the ballpark, okay? So we prove criminal conduct. We have this high threshold is mandated by the Constitution that defendants are presumed innocent, and the burden of proof rests on the prosecutor. Now, we're going to talk about justification and excuse defenses in chapters 5 and 6 after the first exam. But what these concepts are is when the defendant is pursuing a criminal defense, either a justification or an excuse defense, the defendant has a burden of persuasion to show that they meet the criteria by a preponderance of the evidence. This is a lesser standard. This one is more clearly defined, 50% plus a feather. And this is going to apply to criminal defenses. So think things like insanity, self-defense, defense of others, these things. So defendants, once they provide notice that they're going to defend their behavior, but with this criminal offense, they need to have a burden of persuasion. They need to persuade the judge or jury by a preponderance of the evidence. Okay. Now, the next part of this chapter deals with the Bill of Rights in the criminal law. It kind of runs through a few of the amendments. We have a class called Constitutional Issues that really delves much more into all of this, if this is something you find interesting. The First Amendment protects freedom of speech. That applies to expressive conduct, so not just words, but actions and behaviors that communicate ideas and feelings, nodding your head, flipping somebody off, all of those things are speech. This applies to the states. States cannot tell you that you cannot speak. They can place some regulations on where you can speak and the time you can speak, as long as those regulations apply to every everyone. So they can say you can't protest in front of the state capitol house unless you have a permit, and that has to apply to everyone. Okay. There are 5 types of speech that are protected. Those are obscenities, profanities, libel and slander, fighting words, and expressions that generate a clear and present danger. Okay. The Second Amendment is the right to bear arms. This has really seen a lot of action in the last 12 years. District of Columbia versus Heller made it an individual right instead of a state right. And it does allow states to provide reasonable regulations on gun ownership. There's City McDonald versus Chicago that applies it to the states, and the Supreme Court's actually hearing another gun case this term. The right to privacy there's not like the word, you have the right to privacy in the Constitution itself, in the body, but we do have a fundamental right to privacy that is based in the First Amendment, the Third Amendment, the Fourth Amendment, the Ninth Amendment, the Fifth Amendment, and the 14th Amendment. All of these contain rights that say the government can't just walk into our house, that we don't have to open our house to government agents, that reserve power to the people, that give us the rights to due process. So all of these rights put together give us some protection of privacy. Okay. These are some of the cases that have contributed to this. As recently as 2003, we have a Texas statute being struck down that made consensual sexual intercourse a crime between same-sex couples. So there is a strong basis for the right to privacy. Now, the Constitution also places some limits on criminal punishment. Barbaric punishments are prohibited. The word cruel, it generally means that disproportionate punishments are prohibited. It's hard to talk about. It also limits like how we perform executions and things like that. I also just notes the idea that death is different. Death proportionality applies to death penalty cases. Therefore, we only execute first people guilty of treason and people who have committed a first-degree murder. There is no other eligible crime for the death penalty in our country. This idea of death is different also reduces who is eligible for execution. So those who are incompetent, those who are insane, those who are juveniles, and those who have an intellectual disability. Please excuse this poor wording. This is the terminology the Supreme Court uses, but a more appropriate terminology is intellectually disabled. Okay. Now, continuing on, under this idea of death is different, we also do not sentence juveniles to life in prison without possibility of parole. Now, does that mean every juvenile is going to be paroled? No, but it means that the possibility of parole must always be on the table. Prison sentences, mandatory minimums are fine. 3 strikes and you're out are fine. Okay. We have the right to trial by jury and criminal sentencing covered in the 5th and 6th Amendments. Sentencing guidelines need to be flexible. They're advisory. Judges can deviate, but they just need to explain to us why. Okay. So this is just an overview of some of the content, a case in the textbook, and if you have any questions about any concept, I just want to reiterate that you should reach out and ask questions. You can use the discussion boards to ask questions, but this is kind of the basic constitutional parameters of criminal law. All right, have a great week, and I will see you again next week for another video lecture.